And congratulations on making it to the national finals, and you're to be commended for continuing on with your studies, even though I know you're all home from school and you could have just started summer early probably, but you chose to do this, and that's great. My name is Ben Glickman. I'm a supervising deputy attorney general with the state of California. Much more importantly, I'm an alumnus of We the People and was lucky enough to be on a national championship team way back in 1995. And you can see we're in the House Intelligence Committee room, so it's just like the real thing.
Hi, my name is Candida Steel, and I'm retired as a judge on the U.S. Civilian Board of Contract Appeals. I handled federal government contract disputes around the country, and I've been with this program for about 20 years, and I live in Annapolis.
Hi, I'm Marcia Holland. I'm now in Missoula, Montana, but my legal career was up as a career public defender in Alaska. I now teach at the law school in Montana here in Missoula, and I too have been involved with this program for many, many years, and I'm so happy that it's happening this year. Thank you for letting us judge.
If you would introduce yourselves.
Good morning. We are Foothill High School's Unit 3, representing the state of California. My name is Shauna Chen.
My name is Suraj Shukla-Parekh.
My name is Annika Kapai.
My name is Darina Wolfe.
And my name is Kiara Sato. We would like to thank the judges, the audience, and the timekeeper for being here today, as well as introduce our coaches, Mr. McBride and Mr. Dedamore.
Great. So it will come as no surprise to you, the question, but I will read it for the benefit of the video. It is number 3. In 2020, we celebrate the ratification of the 19th Amendment, which recognized the right of women to vote. Despite recent controversy, the Equal Rights Amendment has not yet been declared ratified. What are the similarities and differences between these two amendments? What impact, if any, has the 19th Amendment had on women in achieving equality with men in the United States and around the world? What are the advantages and disadvantages of states passing their own equal rights amendments rather than ratifying a national constitutional amendment?
Our nation prides itself on its commitments to equality, yet intentionally omitted any references to women in its founding documents. However, with the progressive era came the official introduction of 2 similar remedies to gender inequality: the 19th Amendment, which granted women's suffrage, and the Equal Rights Amendment, which would make gender-based distinctions in legislation unconstitutional.
Although passed in Congress decades apart, these amendments were seen as the necessary steps in the movement toward greater gender equality. It was logical to ensure equality in laws after giving women an equal vote. Additionally, Alice Paul, a well-known suffragist and author of the ERA, was a key figure to both amendments.
Nevertheless, there are clear differences. The 19th Amendment aimed to make the government more inclusive to women, requiring their voting power or election into office prior to enacting changes in legislation that benefit women.
On the other hand, the Equal Rights Amendment sought to confront centuries of institutionalized patriarchy, which defined the traditional roles of men and women. If ratified today, state legislators would have 2 years to revise any laws with sex-based classifications. These changes would be done regardless of voter engagement.
Within the United States, the 19th Amendment played an integral role in women reaching true equality with men. Prior to 1920, many state laws prevented single women from owning property. Additionally, due to limited jobs and low wages, women were encouraged to marry and have children in order to ensure financial security.
The initial impact of the 19th Amendment was the ability for white women to advocate for their interests by electing representatives. However, women of color were often denied equal participation in government due to voting barriers that were not prohibited until the Voting Rights Act of 1965. Afterwards, more legislation was passed to improve the rights and expand the opportunities of all women.
Perhaps the biggest impact the 19th Amendment has had is raising a new generation of women who felt inspired to fight for advances such as greater accessibility to birth control and fairness in the workplace. An equal vote was symbolic of an equal voice that they could use to advocate for greater independence for men.
However, the 19th Amendment was not the revolutionary catalyst for women achieving equality worldwide. At the time of its ratification, 7 countries had already adopted women's suffrage, with New Zealand being the first in 1893. Regardless, the United States suffragist movement worked in coordination with the shift towards greater gender equality around the world and set an important model as a global superpower.
Opponents may argue that due to the 19th Amendment and state protections, a national equal rights amendment is no longer necessary. Yet our unit believes that state ERAs cannot replace a national amendment.
There are disadvantages to only states ratifying their own ERAs. For example, Louisiana did not ratify the national ERA, but instead adopted their own in 1975. Constitutional scholar and conservative pro-life author Paul Benjamin Linton has praised Louisiana's ERA for including birth and age, allowing the state and government to more strictly regulate a woman's reproductive rights.
On the other hand, it is important to recognize the advantages of having state ERAs in our system of federalism. 25 states have already acted as laboratories of democracy and refuted some common misconceptions associated with ERAs, such as women losing access to certain existing benefits like alimony and child custody. However, family law court decisions have proven that these benefits would remain constitutional, provided they are given based on biological function rather than on stereotyped sex roles.
Overall, our unit believes we should ratify the Equal Rights Amendment to have a uniform interpretation of what constitutes equal legislation. Ultimately, a national amendment would finally expand the bedrock principle of our government that all men are created equal and equal justice under law to fully include women in the United States of America. Thank you.
I believe Judge Steele has the first question and she's just unmuting herself.
Exactly so. Good. Well, you just said that you think that we should ratify the ERA. Do you think there's any reason why the archivist couldn't just accept it for ratification and declare that it's been ratified and add it as an amendment?
I think one of the reasons that we cannot use the previous Equal Rights Amendment and ratify it and add it to the Constitution is because the Supreme Court decided that the extension to the deadline for the ERA was unconstitutional, and then the original deadline of 1979 was already expired.
Additionally, even if we wanted to ratify it today, Virginia, which was the 38th state to ratify it, which is all you need to ratify it, Virginia was the 38th state, but there were other states that withdrew their ratification, so therefore there would not be enough states to ratify the ERA.
But hasn't there been case law that says that you can't de-ratify?
Absolutely. Despite there being case law that says that states cannot de-ratify, we believe that would be more legitimate for our country to just re-go through the process of the amendment process as outlined in Article 5 in order to ensure that when an equal rights amendment is added into our Constitution, it is done so with the approval of the 38 states.
So let me follow up on that point. The STOP movement had grave concerns about the current proposed language in the ERA, including Section 1 and Section 2. You mentioned that there are 25 states that are basically laboratories for democracy. Have you found any particular states' equal rights amendment language the strongest and one that you would want to adopt?
Yeah, I think that Wyoming's Equal Rights Amendment is, I really like the language of that amendment just because it enshrines that women and men are equal from birth instead of just that they're equal in the Constitution. And I think that we should follow that wording in a national Equal Rights Amendment.
In addition, I think California's Equal Rights Amendment is something that we should model the language of because it essentially mirrors the language of the Civil Rights Act, Title IX, which I feel like adequately adequately ensures equality for men and women.
Also, another state equal rights amendment that we could model off of could be Florida's, which does state or re-emphasize the idea that men and women are both entitled to life, liberty, and the pursuit of happiness. And I think that would be an important thing to enshrine in our Constitution today.
Thank you. So I guess my basic question is, do we need the ERA at all? Why isn't the Equal Protection Clause of the 14th Amendment? Why isn't that enough? We could just interpret that and apply that robustly, and shouldn't that be enough?
I actually think that the Equal Rights Amendment is important in expanding federal protections to the LGBT community. Because the amendment uses the word sex, I believe this can be interpreted to apply in this way, and this would allow the LGBT class to be to have protections because currently in 29 states they do not.
I agree. I also think that ratifying the Equal Rights Amendment would be incredibly important symbolically, because if the current generation grows up with an Equal Rights Amendment ratified, they are more likely to believe that women are enshrined in the Constitution and go for jobs that are more considered more important, which would kind of enshrine that women are as qualified as men in the United States, and even maybe close the wage gap.
I think
Additionally, we can
another.
see that we can see that the 14th Amendment wasn't enough to guarantee women's rights, as we can see in Castle Rock v. Gonzalez 2008, where a woman was told that her husband, like not given custody of her children, and her husband then murdered her children, and that was not a accurate protection or adequate protection of her children. So we can see that if we had ratified the ERA, we would have been able to give the mom custody of her children, and therefore would have protected her children.
Are there any circumstances, and you touched on this a little bit, but are there any circumstances where it's appropriate for government to distinguish based on sex or gender?
I think it's important. The government should distinguish between gender in regards to combat. I agree with the Supreme Court case Rusker v. Goldberg, 1981, that said, in Justice Rehnquist's opinion, he said that women and men were not similarly situated for war, and Congress's exclusion of women was constitutional, and I agree with that.
I also think that treating people different based on gender could be applied to affirmative action, in which people get kind of benefits for their gender if they are discriminated against or a minority. And I think that this helps with the college process because it gives people an equal opportunity and just a better opportunity for a college education.
I believe in a scenario that we shouldn't distinguish between the sexes, even though kind of we would assume that we would be in terms of maternity pay and paternity pay. I believe we should follow Iceland's model, in which we grant both parents, even if they're not the biological parents of a child, paid off time leave, which would ensure for greater gender equality in the country in all aspects afterwards.
Time.
Okay.
You're muted, Candy.
Good, sorry. Excellent. I couldn't get the question in anyway, so I turned myself off instead of. There, sorry.
Judge Holland, you want to lead us off?
Sure. I was very impressed at your prepared remarks in terms of just the points you began with, that in fact it is rather startling that there's nothing in our government's founding documents that ever mentions the word woman at all. So I think that's a really powerful way to point out what it's taken to get us to having this discussion now in 2020 about whether there should be a national equal rights amendment, either adopted anew or ratified. So I really appreciated that timeline and the thoughtfulness with which you realized that this is an ongoing problem. I thought that was really, really good research and really, really good presentation. I liked the laboratories of democracy. I wish that I could be a question hog because I had a lot more questions about that concerning the one I asked, but I wanted to be fair and make sure we could get to several questions. But you did a great job and actually provoked a lot of additional thoughts I had. So I only wish this was longer, but great job. Thank you so much.
Thank you.
Thank you.
Yeah, I would agree. I thought the prepared remarks were very well done and had some interesting takes on the question. In particular, I appreciated, the noting that both of these amendments, the 19th and the ERA, they sprang from the same movement, right? It's inaccurate to say that they're separated by 60 years. They're really only separated by a couple as far as where the germ of the idea came from. And I think that's an important starting point. And I also liked your description of what they were intended to do. 19th, make for more inclusive government. ERA, tumble the patriarchy. And so I like that. And I also agree with the advantages and disadvantages of state versions. I thought you did a nice job there. You left like a kind of a dangling notion of this biological function versus stereotype. and I don't know if you just did that to like lure me in, but if we had more time, I would have been probing that concept more. On the Q&A, you answered all of our questions. I think you probably could have rattled off all 26 states' equal rights amendments and what they say or don't say, and if I hadn't cut you off. But yeah, I thought it was a great conversation. You had good examples and well-reasoned answers. So very nicely done.
I agree with both my colleagues. I thought it was a wonderful, thorough, well put together presentation, and you did a great job on all of the questions. I particularly appreciated your comments about the ERA and whether it should go forward. What I really want you to do, though, is look around. I'm sure you've been really busy for the past few weeks preparing for yourself for this, and I hope it's been a wonderful experience. I hope you've enjoyed it. It's inspired your intellect and especially taught you what it means to be a really good citizen, and I'm sure you'll all be wonderful citizens the rest of your lives. You'll get out there and vote, and you'll know what you're voting about. But I think you've shown that you're worthy of doing more than just being an excellent citizen. You would be wonderful to represent us as lawyers or judges or representatives or senators or whatever you'd like to do, local government or school boards or anything. You certainly have a very fine understanding of what the Constitution is about and what it can do to serve us all. And I think you understand what have an understanding of what the country needs. You certainly know more about the Constitution than a lot of people do at the moment who are in government. And you probably know a lot more than anybody in my law school class knew while I was in law school. So congratulations, you've really got something that you can put under your belt and be proud of and enjoy the rest of your lives. I hope it will be something that you will treasure and cherish. Thank you. I will cherish talking to you today. Thank you.
Thank you.
Thank you.
You and your families and your teachers. Thank you for
Yes, yes.
Thank you, Mr. Denimore.
Thanks, Mr. Denimore and Mr.
Thanks, Mr.
McBride.
Denimore.